Assalamualaikum, my name is Muhammad Hafiz bin Saifuddin.
My name is Syahrul Haziq bin Muhammad Salim.
My name is Muhammad Fikri Mujahid.
My name is Muhammad Aiman bin Abdul Razak.
My name is Amir Kamal bin Nizam.
My name Awang Muhammad Khairi bin Jamaluddin.
My name is Muhammad Farizal bin Muhammad Rasli.
My name is Sazia binti Majanan alias Abu Jamil.
Hi, my name is Nur Farahin Amira binti Muhammad Iwan Faris.
My name is Marina binti Muhammad.
My name is Nurul-Najah binti Muhammad Aziz.
My name is Nur Sabina binti Ismail.
My name is Haris Meka.
Name case Waiha Travel and Tour Agency versus Datuk Sri Muhammad Azmin Ali and his 4 children. Plaintiff Waiha Travel and Tours Berhad. Defendant Datuk Sri Muhammad Azmin Ali and his 4 children. The fact of the case is Waiha want to claim 328,901 ringgit Malaysia to unpaid flight ticket and hotel accommodation involving travel between September 218 and August 219. In another case, Datuk Sri Muhammad Azmin Ali want to be counterclaim to against the Waiha Travel and Tours Berhad by the claiming that the suite was related to a controversy of sex video involving him.
Today, I want to tell you about legal issue of the case. First, Datuk Seri Muhammad Azmin Ali is responsible for the unpaid travel claims, while HA Travel and Tower STMHD is responsible for counterclaim related to the conspiracy of sex video involving himself, namely Datuk Seri Muhammad Azmin Ali. Second, the decision case. The case settled the claim that had been made in secret in accordance with the terms of the settlement. Withdraw the case without an order to pay costs and without the freedom and agreed to withdraw the counterclaim and paying costs of RM1,000. Okay, thank you.
General reasons behind the case. Plaintiff have to pay for the flight ticket and hotel accommodation in advance by the firm. Defendant YHA Travel and Towers Sendirian Berhad had a conspiracy involving him. So, opinion on the case or conclusion, agree or disagree. They solve it very well, and I also agree with the way they deal with this problem. Have to increase efficiency and better management. Thank you.
Now I want to tell about the food poisoning case. Okay, name of this case is the Hotel Renaissance versus National Athlete. Okay, the plaintiff in this case is Hotel Renaissance and the defendant in this case is National Athlete. Okay, the facts of the case is the management of Hotel Renaissance, which is the location of national contingent in the village, rule out the possibility food poisoning involving Malaysian athletes. According the Head of Communication and Public Relations, Melan, so far it has cooperated well in the investigation. So I will pass the next issue to my friend. Thank you.
Now I want to talk about issue of the case. Should Hotel Renaissance be responsible for problem that arise? That the decision of this case, the Ministry of Health Malaysia (MOH) and Kuala Lumpur City Hall have repeatedly acknowledged that the procedure and level of hygiene used by Hotel Renaissance exceed the criteria set international standard HACCP hazard analysis and critical counterpoint.
So I will continue with reason behind the case. So that case is food poison. So the reason behind the case is the Ministry of Health has made a more in-depth study in order to obtain a truly satisfactory result. The level of cleanliness in the hotel exceeds the set criteria. So next point is conclusion or opinion on the case. So in my opinion, Hotel Renaissance should not be blamed for the problems that befell the athletes. It's because the hotel has ensured cleanliness in preparing meals is at the maximum level. So after the conclusion, I think that's all to complete the food poison case. Thank you.
Thank you to my friend. Now I'm going to talk about case number 3, which is unemployment benefits. The name of the case is Debussy vs. Davidson Hotel Co. LLC 2018 WL3431719. The plaintiff name is Debussy and the defendant name is Davidson Hotel Co. LLC 2018 WL3431719. The fact of the case is plaintiff was employed by defendant hotel. He sought a 1-month leave to assist his terminally ill mother. The leave was denied because plaintiff had not worked for the hotel long enough to qualify for federal or state family leave. He then resigned to avoid termination for abandonment and to conclude his employment on good standing for possible re-employment. He submitted a resignation letter that identified the reason for his departure as a family emergency and later applied for unemployment benefits. Next, my friend will continue.
Okay, I want to explain an issue of the case. The relevant New Jersey statute provides that people who resign from their position are not eligible for unemployment benefits although the employee leave for good but personal reason as plaintiff did. The decision of the case. The court thus affirmed the decision of the administrative agency that plaintiff is not entitled to unemployment benefit.
The rationale of case. Plaintiff was employed by defendant's hotel. He sought a 1-month leave to assist his terminally ill mother. The leave was denied because plaintiff had not worked for the hotel long enough to qualify for federal or state family leave. Okay, my opinion on the case, in my view, I agree with the court because court decision for fear of his work being disrupted. In addition, the plaintiff also did not meet the condition to apply for unemployment benefit. Further, the leave application period for the plaintiff is too long, and this can cause the defendant's hotel to incur loss and shortage of manpower.
Name of the case is Tenshel Viramadalan Singh, Hotel and Conference Center. Plaintiff is Tenshel. Defendant Hotel, Hotel Conference Center. Fact of the case: when entering a hot tub at defendant hotel date on 2/2018, plaintiff fell. Plaintiff attributes the fall to a broken support bar leading into the tub. Plaintiff sued and the parties purportedly agreed to a settlement. Defendant prepared a written settlement agreement and submit it to plaintiff. The documents include a Medicare addendum. Defendant attorney told plaintiff counsel to advise if he had a problem with any of the wording. Plaintiff returned the signed documents to defendant but unilaterally crossed out language in the addendum. Plaintiff now seeks to enforce the settlement agreement. Defendant argued the agreement was not valid because defendant was not willing to agree to the settlement without the eliminate clause.
Legal issues. Plaintiff agreed that the clause that was crossed out was not an essential term of the settlement agreement, so there was still a meeting of the mind on all the essential terms. The decision of the case, the court rules the parties did not reach an equitable settlement agreement. Case dismissed. The rationale or reasons behind the case: the defendant did not win the case because both parties do not reach an equitable settlement agreement. The settlement agreement is not valid because the plaintiff was not willing to agree to the without the clause.
Conclusion. In my opinion, this case is calm. I agree that this case is rejected by the court because the defendant should have a clearer discussion with the plaintiff to get an agreement to bring the case to court.
Case 5 is a contract, and the name of the case is Claris versus Hotel Development Service. Plaintiff is Claris and defendant is Hotel Development Service. Fact of the case is, per contract, date on the August 2005, the defendant agreed to build the plaintiff a 4-floor hotel in according with what the plaintiff had planned. His hotel have 122 rooms, which plaintiff planned to operate as a Candlewood Suites. So construction was complete in late summer in 2006. But suddenly in 2013, plaintiff hotel began to experience water penetration when it rained. Plaintiff expert witness investigate the construction work of the defendant hotel wall and identified 5 deficiencies. The expert include one of the 5 root cause of the water problem, but did not identify the extent to which the other 4 had caused the damage. And legal issue of the case is, should the defendant be held responsible for not doing the duty? So in this case, the defendant is in that duty. The decision of the case, the court decision was in favor of the defendant. So the court granted victory to the defendant. But why can defendant win while the defendant is in the duty? So the reason why behind the case is defendant won the case because plaintiffs failed to prove that defendant breached the contract and the cause of the leak at the hotel.
For the opinion, we do not agree. In our opinion, the examination of the defendant should be reviewed so that justice can be given fairly. This is because such incidents can cause harm to customer or hotel staff. In fact, it will also cause loss of the plaintiff due to damage done by defendants. Before counting in determining, justice must be emphasized so that the possibility can be avoided by the various parties involved. The plaintiff must be granted inspection so that any deficiency committed by the defendants can be rectified before moving on the next step. This can intuitively prevent shortage or damage on the part of the plaintiff hotel. Cooperation between the 2 parties play an important role so that there is no misunderstanding between the 2 parties, so the relationship between the 2 will be quick.